We'll start with the. I'm audible, sir, right? Okay.
Yes, sir. You are audible, sir.
Audible, and shall I
But is the
start?
slide not visible, sir? Slide not visible, sir.
I'm trying to do it. I'm trying to do it. Window, yes. PowerPoint slide. Is it visible, sir? Now. Disclaimer and copyright.
Yes, sir. It's visible, sir.
Yeah, I think
Yes,
it's
sir.
movable
Yes,
also,
sir.
right? Okay. So this one, intellectual property rights, it may be a different topic for you, like it is a unique topic for you, like, but nowadays intellectual property rights plays a major role in our day-to-day life. Intellectual property becomes, it is just granted for any inventions or literary artistic work, aesthetic designs, paintings, songs, and you can, it can be any industrial designs for images also, right? So anything created out of human mind that has been having a innovative in nature, if it is not protected properly, then what will happen? So here the intellectual property creation, after creating it, creation of human mind, whether the creator or the innovator gets the right royal benefits or legal rights over it or not. So that is a big question because the inventors or innovators, they put all their efforts throughout the years to create a new invention or a kind of a new design or whatever it is, like trademark, logo or symbol. But they may not be they may not be having the awareness about how to go for a protection. So this intellectual property rights protection, especially through various means of patents, designs, trademarks, copyrights, and other forms of IPR. They give an, kind of a protection for the innovator, and they can do the business without having any kind of a difficulty with the competitors or with the nearby people also who are involved in that particular business. So they get the exclusive right. Intellectual property rights is been given by the Government of India under the Ministry of Commerce and Industry, Department for Promotion of Industry and Internal Trade, under the various banners of intellectual property formats. The protection has been given either in the form of a certificate or in the form of a design registration number. Kind of protection has been given to the innovator, who can have a business without any hurdles or without any kind of obstacles from the competitors. So they get the exclusive rights. They get the exclusive rights out of that particular protection. And out of that, the rights are territorial in nature. That is valid only in India if they are being protected only in India, Indian patent system or Indian trademark system or whatever it is. So for any protection of your IP, you should go for a protection in that particular country. So this particular IP protection is always territorial in nature, and it can be legally given the license to somebody else. You are excluding the others not to copy it, not to infringe it, not to have any kind of legal rights on that, since you are the monopoly right for that particular innovation for a certain period. For each and every form of IPR has its own time period or lifetime period for its IP protection. So after protecting it, what do? You exclude others and you have the exclusive rights on the IP, and you can do or utilize the same thing for commercializing it or earn it through by various means. So that is the reason this IP creation and protection coming under the banner of the Ministry of Commerce and Industry, Department for Promotion of Industry and Internal Trade. So what do I do with the protection, IP protection? You can use on your own, since you are the exclusive rights, you have exclusive rights. And suppose if you don't have that infrastructure, or you don't have that kind of fund or whatever it is, like you can merchandise it or franchise it or legally give the license or assigning it to somebody else with the agreement, non-disclosure agreement. Based on that, you can have any kind of earning also, like. So out of all these protections, of your own use, you earn it, and if you are licensing also, you earn it. Merchandising it or for franchising it also, you can make use of it. So as a common person, as an individual, mostly it is a pride, and as far as academics is concerned, it is just becoming a paper patent or paper protection, but it is becoming a pride for each and every people who can have a different kind of protection always, so that the people can earn it with the earn the pride, and as well as they can get the protection. And apart from that, the they can do any kind of business at any point of time. So they can do any kind of business at any point of time, since each and every protection has its own lifetime period. Like we'll have one by one in the slides. So as a businessman or a multinational company, they are commercializing it properly with the new technical features of the innovative product, coming with the brand value, with the confidence in the customers, and out of that they earn more and more, and further they do the investment in the research and development to further argument optimize their own products in the research. So with this, I think with an example of tea, sip of a tea. This example, I think it is not there. I'm sorry to this thing. With the example of sip of a tea, which is prescribed by World Intellectual Property Rights Organization, they give the awareness. What are the different formats of tea? What are the different formats of, you can say that IPR is available in a sip of a tea. So the sip of a tea, when you like, when a particular person is asking for a particular name of the tea, like a branding, that branding of the tea, which always gives you a kind of confidence or a flavor or a taste, which is the consumer is attracted towards it. So that is called the branding thing. Like the creator, or the IP creator, or the brand, the particular business which is involved in the tea, they create a name or logo with Taj Mahal tea, with the name, or they create a logo, the combination of lines or combination of colors. So with that, the flavor of the tea, the technical characters of the tea has been increased, optimized, and the consumers always have been attracted towards that particular brand because of that technical characteristics. So that is called branding thing, branding, creation of a brand under the banner of trademarks. So when you create a name or logo or symbol, that can be protected in the form of a trademark. So like, for example, Taj Mahal tea and various brands are available. Like even the one line logo or one line tagline can also be protected under the name of the under the banner of trademarks, IP or trademarks. So that is one form of an IPR in the sip of a tea line. And the kettles designs, the tea manufacturing machines, the kettles, the cup and saucer design, or the tea bags design, even the immersible tea bags designs, which is having a aesthetic appeal or look and feel appeal with the naked eye, with their photos and with their front view or top view photos, then that particular product with the aesthetic appeal, which is applied to an article, that design can also be registered under industrial designs. So that is another form of an IPR, in which the kettle designs, the tea production machineries designs, or tea bags designs can be having a aesthetic appeal, which can be protected in the form of an industrial designs. So that is another form of an IPR, which is having the IPR protection in the sip of a tea line. And when you write a book or a poem or a one-line poem or something like that, you create a manual or whatever it is like for a particular brand of a tea or particular brand of a product or whatever it is like a nice cup of tea, then that becomes you deem to have a copyright protection. So that kind of a literary work, artistic work, the painting work, these things can be protected in the manner of copyrights. So a nice cup of tea, that can be protected in the format of copyrights. And when you develop a new tea recipe, when you develop a tea recipe, that particular recipe can also be protected under the trade secrets. So with several examples like the molecular formula which is used for manufacturing or production of that fabrication of that Pepsi, Coke and KFC chicken, that masala, the recipe, that can be protected under the trade secrets, not trademarks. It is called trade secrets, which is having international protection. Like. So several other forms of protection is also available. So in tea, when you develop a new tea recipe, that particular tea recipe can be protected in the trade secrets. And the particular tea variety which is coming out from the uh, particular origin, for example, from Kunnur or Malabar or Darjeeling, Assam. So from that place, from the particular geography origin, if the tea is having some kind of taste which is directly attributable to the geographical origin based on the soil conditions, climatic conditions, water, and several other factors which is belonging to that particular origin, then that is directly attributable to the technical reputation of that particular product. So that product, it may be an agriculture product or manufacturing product or whatever it is may be. So that becomes the protection under geographical indications. தமிழ்ல புவிசார் குறியீடுன்னு சொல்லுவாங்க, geography indications. Assam tea, Darjeeling tea, or whether various other forms of other varieties of tea, Kunnur tea or whatever it is like. So you have several examples. We have several examples for that geography indications. And when you develop a new plant variety, tea plant variety, when you develop or grow or cultivate a new tea plant variety, that plant variety can also be protected in the manner of Protection of Plant Varieties and Farmers' Rights Act. Protection of Plant Varieties and Farmers' Rights Act. So that is another form of a protection, which is can be in which the plant varieties can also be protected under the banner of Protection of Plant Varieties and Farmers' Rights Act. So you can create a new plant variety, or also the existing extant variety can also be protected under the Protection of Plant Varieties and Farmers' Rights Act. So these are the different forms of IP creation or IP protection in the sip of a tea. And the most technical part, the most important, or the most, we can say that the most techno-legal part of the protection comes under the category of patent. So you have tea leaves, and the tea leaves are converted into tea flavors, tea crystals, or whatever it is we call, and they pack it and give it like. So this process of conversion of tea leaves into tea dust, then that the process or the methodology or the machineries or the um, manufacturing kind of equipments or apparatus which have been used or utilized to convert the tea leaves into tea dust. So that entire process or methodology, the devices can also be protected under the category of patent. Since it is involving more technical in nature, but of all these IPRs, patent plays a major role in which the technical and legal parts are combined together to give a right kind of protection in the right kind of a mixture for a period of 20 years. So this patent is one of the most technical part, and it is applicable to all the academic people, research people, students, and the faculties, even, I mean, and apart from all these people, apart from all these individuals, the multinational companies which is involved in that particular field and the field of research, they develop, they optimize their own research and development and come out with the new features of the new product. They go for a protection under patent, which is valid for 20 years from the date of filing. So that is the validity period or lifetime period for a patent. And similarly, the industrial designs will also have a kind of a protection for a period of 10 to 15 years. And all the IPRs, by paying a renewal fees after getting the patent certificate or design certificate or IPR certificate, the renewal fees has to be paid in uh, on time, so that the validity of the IPR protection remains good for the inventor or innovator or patentee holder to go along with the business without any hurdles. So trademark, even the sound marks can also be registered. Recently, the scent mark has been registered under trademarks. Scent mark, which is involved in the tires, which gives you when it is running at a particular speed, that particular tire with this speeding thing, it gives a kind of a rose scent smell. That kind of a scenting smell mark can also be registered under trademarks. Recently, it has been granted as a trademark registration. And the trademark lifetime period is for again 10 years. Further, you can uh, renewal it for another 10 to 15 years. So maximum period, maximum 20 years. And copyrights, for each and every class of, you have different classes of work, literary work and artistic work, painting work, books. All these works are classified, and accordingly, the maximum lifetime period is given to 60 years from the death of an author, for copyrights. And geography indications, it is for the period of 10 to 15 years. But again, by paying the renewal fees then and there on time, you get the complete protection for the entire time period. And with the example of tea, we have got the different forms of an IPR, like the tea products, tea leaves to tea dust, that can be protected in the process or the methodology, or the technical equipments which can be protected under patent. And the designs which is involved in that, the machineries or cup and saucer, that can be protected under industrial designs. And the trademarks, which can have a branding, name, logo, combination of lines and colors, that can be protected under trademarks. With branding of teas, like we have several Lipton tea and several other brands of teas. And copyright, when you write a book, it is deemed to have a copyright protection. And when you develop a new plant variety, that can be protected under Protection of Plant Varieties and Farmers' Rights Act. And the plant variety which is grown up or cultivated in a particular origin, which gives you a new technical or reputation, has been directly proportional to that quality of the product, then that it becomes liable for protection under geography indications. And with the example of, we can say that smartphone. In the smartphone, we have different types of IPR, like in the sip of a tea. The we all know that the semiconductors has grown up in a huge manner. Even previously, like we had in the 70s and 70s and 80s, the small scale integration was there. Like the integration chips were designed in a smaller manner. We all know that the size of the computer when it was designed previously, like in initial years, because of the size of the integrated chips, and the small scale integration has become a large scale integration, then becomes a very large scale integration. Now millions and millions of transistors have been integrated into a single chip, which can optimize the processing speed of a particular machine or processor or a mobile phone, whatever it is. Like that particular architectural design can also be registered under Semiconductor Integrated Layout of Circuits Act. So with the mobile phone thing, uh, we have several forms of an IPR. The optical lens mechanism, or the layout of integrated circuits can be protected under for the architectural design of the integrated chips, and the processor can be protected under the patent, the optical lens mechanism, and the materials for which it is used that can also be protected under patent. The manual or the booklet, whatever it is designed for working manual of that mobile phone, can also be protected under copyrights with the C symbol, and the branding thing can be protected under trademarks. So each and every product, even if you take for example with a brush, the particular brush will have at least three forms of an IPR. One is under the trademarks, whereas with the Pepsodent, Oral B, or whatever it is like. And the design of the brush can also be registered under industrial designs. Industrial designs, the design of your ornaments, design of your shoe, design of a jewelry, everything can be protected under if it is having an aesthetic appeal under the naked eye. If it is examined, then that particular design can be registered under Industrial Designs Act. So this smartphone, this can be covered. We all know that this smartphone is having n number of patents. N number of patents, thousands and thousands of patents are being protected in the single smartphone. So each and every innovative nature or each and every innovative feature which is involved in the new models or new technical versions of the mobile phone has lots and lots of patentable protection, and with the front end design and back end design of the camera can also be registered in industrial designs. The copyrights can be having the manual of the working manual of the product, and the trademark with the Apple, Samsung, with the various names and logos can be protected under trademarks. So with the patents in 2015, the Global Innovation Index of India was standing in the position of 81st. But after very long innovations have come, with the large scale revolution has happened in the MSME sectors. Now we are standing in 39th position in 2024 or 25. So, as per the definition of the Patent Act 1970s, it is very long, 150 years old, but it is an exclusive right. It can be given it can be protected under a banner of can be given protection can be given to product or as process, but it should have a new novel method and should have an inventive step if it is not novel, and technical solution. It should have a technical problem and the solution has to be given. That solution should be technical in nature. So that is the reason like the patent has been granted to only techno-legal. The document which is produced to the patent office for solving a technical problem to technical solution in order to get the protection for patent, then it becomes a technical solution. The technical solution should be there, like it should be available in the documentation which you are providing for the protection of your patent. That should be technical in nature, and that is the reason like the patent is standing apart from other forms of an IPR, and it's exclusive right for making, using, exercising, or importing whatever it is a limited period of 20 years. It is excluding others using your invention. Even the hanging technology has been granted long back. Safety pin to satellite. You have lots and lots of technical problems and solutions. The technical problem solution has been protected in the form of patent if it is properly documented in the patent office, and if it is satisfying the criteria under section 200 and 3K of the Patent Act and several other sections, rules and of the Patent Act, then it can be available. It can be granted as a patentable subject matter. I was telling you an example with the brush in the brush one. The design of the brush can be registered under industrial designs, and the bristles, eco brush, or the throwaway brush. These things can also be registered under industrial designs, and the brushing mechanism has been granted as a patent by an Indian inventor as well as a US publication number. So this gives you the complete picture about even the brushing mechanism is we may not be knowing the right way of, we may be knowing the right way of brushing, but we are not in a position to practice it because of our emergency and because of the urgency and various other factors. So this has been seen as a technical problem by a dentist, and he has developed a new kind of a brush in which he has put some kind of material into it in the neck portion of the brush, and because of that, the neck portion material which is embedded or inserted into that neck portion, which will create a sound when you make up and down. That is the correct way of brushing, which creates a kind of a trigger to the user, so that the user gets an alert signal that you are using in the right direction, not in the back and forth. So even the back and forth motion will not have any kind of sound, or it will not trigger any kind of sound, even though the material is in the neck portion of the brush. So this particular brushing mechanism, along with the design of the brush, has been granted as a patent and industrial designs. This girl, I mean, why this slide is like any person, anybody can have a patent. It depends on, I mean, age is not bar. Even the inventor can become 6 years. Recently, I have seen a application, patent application, in which the inventor is 8 years, and his father has developed a MSME or a small entity in which they have developed a kind of AI model thing, and they have developed a kind of a what do you call the self-learning self-learning musical kit that has been developed by that boy who is of 8 years old, and his father has represented as a legal heir to apply for a patent, and he has appeared recently in the hearing also. Like, so that hearing kit has some kind of materials in which the person, visually impaired person or the normal person, can have a, I mean, the mechanical portion in which it creates a kind of a musical thing. They can recognize it, and they can recreate the recreate and learn the music on their own. That particular kit has been applied for a patent that has been done by a school student of years of 8 years age. This girl, she has invented an automatic multifunctional life rescue flood house, and she has achieved significant achievements in the field of innovation at a young age, and she has been awarded this Pradhan Mantri Rashtriya Bal Purashakar Award 2022, and this is the patent application which has been granted as by the patent office once the documents are in line with the patent act rules and regulations. So this patent documentation, it is equivalent to the IP patent protection. It is patent documentation preparation. We can say that it is equivalent to a kind of the research paper work or the dissertation work, which has been, or the project documentation work. It is equivalent to that, but the patent specification, patent document is the kind of a techno-legal document. It is a combination of technical character as well as the legalities under Section 21G3K and various other sections of the Patent Act. It has to abide by the rules and regulations of the Patent Act. So that is a major difference between the research paper work or dissertation work or the project documentation, which are purely technical in nature. And you can say that even the journals also, like, which can be converted into a patent document easily, but it has to have the legality in line also. Like, so in order to prepare a patent documentation, we all know that the IP protection, we all know that how to register a immovable property like plot or flat. Like, so we do all kind of homework, setting up the boundary of the particular land or flat, taking the market value, taking the guideline value, considering all the other features and parameters which are favorable to a person who is going to be the purchaser. Then after going through it, we go for a kind of a legal opinion to the legal expertise. What are the various any kind of legal implications have been involved in that, or the various transferees or the various proprietary ownership which has been from the several years. Like, so we check all these documentations, we check all the things, and go for a loan processing. That is a separate thing, and produce all those documents in front of the person who is sitting as a document writer in the sub-registration office. The document writer only see when you go through the thing with the advent of AI, we can write on our own. But is it possible for us to do it on your own? Like nowadays, like the registration department has come up with technical writing or online submission also. Like the recent development has come with the online submission of the documents. You can do the online registration also. Like that kind of development also has come, but still, I mean, if there is any discrepancy or this thing, we go to the document writer. The document writer sits down and he is writing in a format which is applicable or according to the Registration Act. And after that, we go through it, verify all the things and boundaries and everything, like who is the previous owner and what is the guideline value, what is the stamp duty, putting all the things in the documentation, produce it to the registration department, register, sub-register. He checks it and with the verification of the seller and purchaser, then he signs the document and the document, I mean, the proprietorship or ownership has been transferred from the purchaser to a seller to the purchaser. Like you become the right royal ownership of that particular immovable property. So once you put the encumbrance certificate, then your name will be reflected in that particular period. So this is how the registration of a immovable property has been happening to get the legal royal rights of that particular property. Same way for a patent documentation also, to get a innovation to be protected under the patent, you have several implications, legal grounds in which you have to satisfy. The documentation has to satisfy all the criteria. Only then it can be protected under the patent. So that we'll be seeing in other slides also. With some examples we can see. Designs is industrial design. It is an it can be an aesthetic appeal, like the features, the shape or configuration, pattern, ornament or composition of lines. Even the composition of lines or colors, it should be applied to an article. It should be applied to an article, whether in two-dimensional or three-dimensional or in both forms. In which process, like it may be industrial process or manual, mechanical, chemical, so different kinds of processes are involved in that, in which the finished article appeal to or judge closely by the eye, judge solely by the eye. So this is the definition given by the Industrial Designs Act. So these are the examples, and the composition of lines or colors. Recently, I have seen in Amazon, in which the seller is projecting his product, in which the it is a kind of a saree, which gives you a kind glittering look, in which the silver linings are embedded in the sari thing, which gives a kind of glittering look. So that particular design of the sari has been protected under industrial designs, and the seller has attached the industrial design certificate to make himself that this belongs to the uh, genuine protection. This product is belonging to the genuine protection, like by industrial designs. So that particular product with the design certification, it is having a particular value, and he is selling it at the nominal price. So these are the examples under in which the designs can also be protected. Or we all know that the industrial designs, the same product, same brand, but the product is different. I mean, the product is the same, and it has been filled in different designs which are unique in nature. Like, so this is how, according to the usage, according to the consumer's usage, and according to the aesthetic appeal, the design has been registered under industrial designs. So this is the only first product wherein you can remember the particular product with the help of a design itself. Usually we remember with the branding thing, branding value. The branding confidence has been created along with the consumers by the MNC company with their trademark logo or something like that, and we are attached to that particular product. But this particular design, which is a unique thing, which makes you to realize that this is a product like. So apart from the branding thing like. So is another example wherein the design is very much unique and aesthetic appeal, which gives a complete confidence that you are using the particular genuine product. So this is an example wherein you can find out the differentiations or the problems or the wrong things involved in the representation of the trademark. So it's a trademark. It is given to a sign which is capable of distinguishing goods or services from one enterprise to another enterprises. So these are the examples. And I heard, I mean, you can put it in Wikipedia or Google, Google it with the Domino's pizzas. There are three dots. Why the three dots have been given? There is a gap, and this has some story also. You can Google it and you can enjoy it. Even the sound marks can also be registered, taglines, slogans, brand names, sound marks. I have given you the recent example, scent mark, which has been for a tire which is running at a proper speed, which gives a roast kind of smell. That scent marks can also be registered in the trademarks. Even here, the sound marks can also be registered, like lion roaring symbol of MGM or the Netflix sound and the Geo Hotstar. So along with the trademark, the sound marks can also be registered. Nobody can make use of that thing in another product. So it is a combination of colors, logo. So your life is good. That is another tagline. Just do it, and I'm loving it. It's finger licking good. L'Oreal, because you are worth it. Trademark. So the trademark has been registered with the that can be represented using R symbol within the circle, which is denotes that this particular um, symbol has been registered, and TM is for the registration pending or in under process. So copyright, it is expression. All the IPRs, it should be have an expression of an idea. The idea should be ideas as such cannot be patentable, but it should be expressed in a format of an idea, which can rights to reproduce the copyright owner. They can reproduce it, translate it, adapt it, perform it, distributing, and publicly display the work. So he has the entire corporate owner has the entire rights to reproduce, translate, adapt. So registration is not mandatory, but still, once you write something else, the corporates deemed to have a corporate protection, but that doesn't will have the complete safe protection line. So it is better to have registration once the copyright comes into existence as soon as intellectual work is created. So it is always recommended to register the copyright for better enforceability, since registered copyrights will have evidentiary value in the court. So here I can say what are the things which cannot be registered under industrial designs or copyrights or in kind of trademarks. Industrial designs, which is the designs which is not having kind of moral grounds or which is contrary to the public health or morality, then that designs cannot be registered like under industrial designs, and which is not distinctive, which is not unique in nature, which is not having some aesthetic appeal, which is not original, that cannot be registered as industrial design. The same applies to trademark also. Trademark symbols, logos, which is not unique, which is not distinctive from the other, or which is not distinctive from one business to another business, that cannot be registered under trademarks. The national emblems, the name of the religious persons, the name of the persons, name of the places, all these things which cannot be registered under trademarks. And the national emblems which have been protected under the National Emblems Act, that cannot be protected under the format of trademarks as well as in the industrial designs. So these are the various works in which the copyrights can be protected. You have if you are writing a book, then it can be protected under literary works. Paintings can be protected under paintings only. So under the class of each and every class, you can protect it and get it protection under the copyrights like. Once I have been told by somebody else that the Tanjavur Brihadiswara temple, the big temple, it was constructed by the Rajendra Chola. We all know that, but there was a symbol in which the uh, persons who is involved in the construction work, they have created on a kind of a certificate. This has been, this particular temple has been constructed by these many people, and during the period from this period to this period, that kind of protection they had it, and they were placed in a placed in a placed in somewhere else, so that the Tamilian people who has got the idea of their own protection, their own product or their innovation to be protected on their own name. Semiconductors, the layout of integrated circuits, it was designed in 2000 and rules was redesigned in 2001, which is a complex series of layers of semiconductors, metals and dielectrics, insulators and everything. Like it can be fabricated, but it should be original, distinctive, and capable of being distinguishable from any other layout design, and have not been commercially exploited anywhere else. Like so, this particular in layout of integrated circuits, recently, not recently, but 2 3 years back, 2 years back, it was registered by one of the college, Muhammad Satak Engineering College from Kerakarai. They have developed a kind of a project in which the protection has been sought for the layout of integrated circuits act. They have filed 2 applications from their college time, and it has been processing. It has been under process. Like so, here I can say that the semiconductors is not becoming a big opener, but still in future, like maybe with the advent of new chips designs and everything, like this will become a inevitable thing in the protection of layout of integrated circuits. Geography indications, we can say that it is a kind of what can previous or குறியீடுன்னு சொல்லுவாங்க. So the products which have a specific geographical origin, which have a specific geographical origin, and the qualities or reputation that are due to that origin. So that is the definition given by, I'm not giving my own definitions. All these definitions have been given by the uh, all these definitions have been given by a particular act, rules and regulations, GI Act. The qualities or reputation that are due to that origin. Kanyakumari cloud, Tirupati Laddu, Mattalam of Palakkad, Kanjivaram silk, Salem silk, Arni silk, Salem வெண்பட்டு, ஈரோடு வெண்பட்டு, பட்டமடை பாய், கொடைக்கானல் மலைப்பூண்டு, கோல்பட்டி கடலை மிட்டாலேருந்து, குலு ஷால்ஸ், சிறுமலை ஹில் பனானா, Malabar pepper, Darjeeling tea, Ooty tea, Kunnur tea, Dindigul locks. So these are the various products which has originated from that thing, and it can be applicable to any agricultural product or food products or manufacturing products. Also the manufacturing products, which is nothing but the Coimbatore bed brand, that is one of the oldest GI protection under the banner of a GI tag. So the major difference between the GI and can say that the trademarks is trademarks, patent, designs, copyrights can be applied by any individual as well as by the MNC, any natural, I mean, other than natural person, we call it as per the act. Other than natural person, in the sense, it may be any company who is related in that particular business. They can apply for the patent, industrial designs, trademarks, and copyrights also. But here in this case of geography indications, police are குறியீடு, since I am coming from this RNE, I cannot claim the protection for that particular thing. Even Madurai Malli. So the individual cannot claim it, or the association or the people who are involved in that particular field of business, in order to protect their business interest, in order to facilitate their business interest, in order to speed up their business, in order to increase their optimize their economical gain, then the persons who is involved in that, they can form an association, and the association shall be registered under registration of societies, and the registered association only can file a GI application in that particular category of the product. So this Kodaikanal Malepundu garlic hill, which is having the pulp is very strong enough. The people who come from Dindikal or Kodaikanal region, they can come to know that the farmers who were cultivating this particular Kodaikanal garlic hill, they were earning very less thing, but the pulp is very strong enough, and the if it is cooked along with the cooked with the new variety of recipe, then that recipe gives a complete new taste. So this and also this Kodaikanal garlic hill is having a kind of medicinal value also. Like you have Erode Manjal is also be protected under geography indications. This Kodaikanal garlic hill with the medicinal properties and along with the historical evidences which has been utilized by the our kings in Sangam era, which is used for treatment of some asthmatic diseases. So these evidences have been produced by those association of farmers along with the Mother Teresa University in Dindikal, Kodaikanal, and they have filed an application here, and geography indications office, which is only in Chennai, not in anywhere in India. It is only in Chennai office. They have collected all the evidences and they produced everything like and filed the application with the fees and with the documentary evidence and everything like, and they will be examined. The documentation will be examined. They will be called for a consultative group meeting, in which the consultative group meeting, which comprises a specialist from that particular product. If it is related to food product, the specialist in the food product can be called for the consultative meeting from the geographical indications office side. Several representatives will be there, and the representatives from that organization or association will be there. So the consultative meeting will be done. Along with that, then after verifying those documentations and historical evidences and various other documentations which is related to Geography Indications Act, then it can be granted as a Geography Indications tag. So the filing fees for the geography indications is with the registration of association is on you. The association can register or file the application with 5,000 rupees. 5,000 rupees is the filing fees, and several other forms to be updated, and we have to pay the fees accordingly. Like so, here after getting registered under GA tag, anybody can apply. Any the interested party who is in the field of business, they can apply for an authorized user. They can apply to the geography indications office to get the authorized user representative certificate. They can get the authorized user certificate from the concurrence with the registered association along with the GA office. They can do the business with their own products with an NDA between them and the association who is liable for the liable for the registration of that particular product. So authorized user is also there, like so you can do the business of the product which is registered under GA tag. You can become an authorized user and make use the product and do the business, and because of that you earn money out of it. So the minimum filing fees is 5,000 rupees for registration of geography indications product, and the fees for filing of industrial designs is 1,000 rupees if you are related to a natural person, if you are filing on your name, and if 5,000 rupees for filing into on your company name or institution name or whatever it is like. Similarly for trademarks, it remains the same. It starts from 500, and you can do the search also, all entry on our website also. Otherwise, you can visit the office and put an application whether this particular, if you are coming with a new logo, you can create the logo and give it to the office, or they can do the search and give it to you that whether it is already been filed in particular classes of work. Like so, it is the filing fees start from 500. For searching fees is 500 and 1,000 to 5,000 rupees. It is for the filing fees, initial filing fees. And similarly for designs, 1,000 for individual users, and 5,000 for the this thing. MNCs companies. So this is the filing fees. I mean, at a nominal price it has been given, and all these filing details or filing fees details are available in our website ipindia.gov.in in different categories: patents, designs, trademarks, copyrights, and geography indications. Semiconductors also there. So with this example again, the logo has been created and logo has been protected under trademarks. User manual has been protected under copyrights. Layout of integrated circuits with the designs and LED displays for the patent. So you, apart from all these things, you have a protection under plant varieties that has been discussed. When you create a new, develop a new plant variety, that can be protected under plant varieties and the Ministry of Agriculture. And trade secrets, the tea trade recipe, you can develop it. Traditional knowledge. So here, I just wanted to give an example which may be known to you, like, but still, it is just a kind of a thing. Like, traditional knowledge database has already been there in our website. And suppose any person who is involved in the doing invention in this particular traditional knowledge database, which is available, which is applicable only to an Indian culture, Indian origin or Indian country, then yeah, they have to look into this particular traditional knowledge, whether we are using the ingredients from the traditional knowledge or not, and because of that, we have to pay back if your product is based on the traditional knowledge database products, and if your product has been granted as a patent, you have to pay back some agreement with the NBA, biodiversity, like, so biodiversity act. So there you have to pay it and get the agreement done, and similarly you can do the business also. Like, this is what the traditional knowledge database mostly it became a big picture once you a US patent, US company has got a patent for that erode manjal as an ingredient, and they have developed a new kind of a drug based on that particular erode manjal, and they have applied for a patent in India also that has been refused. So they refuse in the sense it is a traditional variety which is traditional knowledge database which is applicable only to India, and accordingly the patent which has been granted in US was revoked based on the traditional knowledge database which is applicable only to India. Like, so that is where the traditional knowledge database plays a big major role, and it is a kind of a protection also for your traditional knowledge thing. Like, so the lifetime period and the gist of summary in which the different forms of IP has been protected, for which kind of protection has been given, and for how many years. Like, so we come to know that this particular. So you can find the IP based on the this thing. Distillery, it is related to trademarks, and Coca-Cola it can be given for trademarks as well as the trade secrets. And Apple designs, industrial designs, trademarks, and Monos as fine is for copyrights. And second, you can guess yourself. We all know that the Facebook has paid more than $60 million to get the name rights, Meta name rights. So the Meta has been protected under some kind of a trademark, and the CEO of the Facebook has paid more than $60 million to get the Meta name rights. And filing fees for the patent is 1,600, or it is like if you are belong to a natural person or a small person, a natural person or a startup or small entity or education institution. So under the banner of your education institution, the Patent Act has been amended, and patent rules have also been amended time to time in order to facilitate more and more innovations and inventions coming out from the small startup companies, MSMEs, and small entities, and also from education institutions. So previously, like the fees was like 1,700 rupees for a natural person. Other than natural person, if you belong to, if an applicant is applicant name is from the education institution, the fees was like 8,000 rupees. Now it has been revised, and this is the fees 1,600 rupees for uh, it is online filing fees. But when you are paying it in person to the patent office in front of the front office counter, the fees is 10% extra, 1,750 rupees. So these are the various forms which has to be produced to the patent office for the filing of patent. Form 1, which gives you the complete details about your name of the applicant, who is applicant. Applicant may be like your college name, MGR, MGR research, research and development, or your college name. And in inventor's name, your names will also come, and title of the invention, signature of all the inventors, how many pages you are going to apply, how many pages of complete specification, subtract, including abstract claims and everything. It should come on around 30 pages. Then the fees is 1,600 rupees if it is a physical filing. If it is online filing, like I mean, if it is online filing, if it is a physical filing, 1,750 rupees, 10% extra. So no, if it is less than 30, if it is less than 30 pages, if it is less than 10 claims for which the protection has been given, then there is no extra fees. Like that is called Form 2. That is the complete documentation of your entire invention. Like it should have all the features of your invention that we'll see in the next slides. And along with that, Form 3 and Form 5 it is not required for you. Form 9 is also there, which is actually recommended for an individual or a college institute wherein we publish it. The patent office publish your documentation, your abstract in the IP journal. Then you file a Form 9 with a fees of 2,750 rupees. So that request for early publication, that gives you the request for early publication, gives you the kind of, it will be publishing, the patent office will publish the abstract, the name of the inventor, the applicant name, and the drawings, the claims, number of claims and everything, the title of your invention. These things will be published in your IP journal. The IP journal will be published each and every week. That can be uploaded in our website, ipindia.gov.in. So you'll be given a email communication, which is given in the Form 1 in the address for service. The valid email ID, the valid mobile phone, the valid address, in which the patent office will communicate through email. Nowadays, it is only through email only communications. Or if the valid email is not given, then it will be giving the mostly with the manual by posting, speed post or whatever it is like. So the valid email is very much essential in filling up the Form 2, Form 1 with the along with your name, address, and email ID and phone number. So this is the minimum fees. Like when you add the Form 9 fees with along the Form 18, most of the people they forget to file the Form 18, which is very much essential to prosecute your uh, instant patent application. Only then the application which is in the database repository will be taken up and it will be classified, scanned, screened, classified. Screening can be done. Then it will be taken up for examination in the automatic pool of examination, and it will be allotted to the particular person, particular examiner who is specialized in that particular field of examination. Suppose if your invention is related to biotechnology, the invention will be allotted, the paper documentation will be allotted to a examiner who is involved in that a particular field of business, particular expertise like biotechnology. So they'll be examining the case and it will be putting up. So that is will be done. The prosecution of a patent application will be done only when you file the Form 18. Most of the people we don't file a Form 18 only. They think that once you file a patent application, they'll get a grant. It is not like that. On the date of filing, the innovator, the inventor, you are the inventor. But when you file Form 1, 2, 3, 9, 18, then the prosecution goes on. Once you get the patent granted certificate, then you become a patentee holder. The inventor becomes the patentee holder. So it is necessary or mandatory to file Form 1, 2, 9 and 18. 9 is optional. Since we'll be publishing your abstract and in your IP journal, that you can put show it in the in your department to get the credit also, since it is a kind of a publication. Why means like people are always the research people, the faculty are always interested in getting the their articles to be published in the respective journals. That is okay, fine. Since you are getting the credit out of it, and it will be used for several other academic purposes for their own promotions or getting more credit points in their department by side. So this publication, which is done by Patent Office, Government of India, in IP Journal, and every week the publication has been carried out, and in that, in your name of the applicant, inventor, and the abstract of your invention has been published. So it is helpful for you to show it in your academic profile. So this is the fees for other than natural person. When you belong to Qualcomm, Google, or any other company like other than natural person, this is the fees, 8,000 filing fees, and Form 18 fees is 20,000. So different forms have different fees and natural fees. These fees structure has been shown. You can refer to the first schedule of the Patent Rules 2003 as amended for more details to get the patent details. But these are the minimum documentations which is required, minimum fees which is required for filing it in the patent office with the minimum fees. So you can do it online or you can do it offline also. You can come to visit the patent office and file it in the patent office counter along with the documentations form 1. 2 is nothing but the complete details of your documentation of your patent. So you can do online filing also with the help of digital signature and e-certificate. So normally when you file form 1, 2, 9 and 18, normally these are the required forms with this fees, with the fees like this, and it will be processed normally with 18 months only after publishing your details and 18 months. If you are not filing form 9, the abstract will be published 18 months after filing date. So after that only the request for examination will be taken up and it will be processed in a normal procedure, normal prosecution procedure, normal route, you can say that. So when you want to speed up, when you want to speed up the prosecution of your patent application, if you are falling under any of this category, then the applicant is falling under any of this category, then it will be rerouted to expert examination. For that, you have to pay the fees extra, and accordingly, the fees will be higher. So the expert examination will make the applicant, if you are falling in any of this category, if you belong to startup, if you have any startup, you can apply it in the startup category. And similarly for small entity, if you become a small entity, the valid documentation has to be given and the documentation will be verified by the patent office. And startup, you get the certificate from Udyog certificate or DIPP certificate, Department for DIPP certificate. Along with the certificate, if you are producing everything in form 1, 2, 9 and 18, 18A, it will be like, if you are proceeding with the expert examination, it will be proceeded with form 18A. That fees is 8,000 rupees for a startup or small entity. And if the applicant is a female, like if you are combining together 2 or 3 people, if an applicant, joint applicant, one female applicant is there, then it will be the prosecution of a patent application will be done in expert manner. That proof has to be given by the way of ID card or Aadhaar card or government approved ID card. And if your office is belonging to department of the government or other government establishments under Rule 24C1, then that particular government department can be can produce the particular documentations and it will be verified by the examiner and the expert examination procedure will be done in a quicker manner. So the expert examination within span of 1 or 2 months, maximum 3 months, the patent has been granted. Within the span of 100 days, the patent has been filed and granted. So when an applicant, when you means like as an applicant, when you choose India as an international search authority or international preliminary examination authority in patent cooperation treaty in which you can file international patents. So this is the route. So when you choose India as an international search authority, then this particular application will be processed in expert examination. So if there is an agreement between Indian Patent Office and Foreign Patent Office, then that's not considered as an expert examination. Like that is called JPO. When you have a bilateral agreement, the Indian Patent Office and Japanese Patent Office has a bilateral agreement, then it will be processed immediately. Like so, these are the categories in which the applicant is a startup, a small entity. If any one of the applicant is a female, department of the government and other government establishments, and India as an ISE, IPA or NITs, if any of the institutes coming, and if any education institute, which is any education institute which is getting the financial benefits directly by the government of India, and when you provide that particular documentation, then it will be processed under expert examination. And any university which is coming under UGC will not be considered as an expert examination, but IITs, NITs, triple ITs, these are the things which are exempted, in which the expert examination has been done quickly. So what I'm trying to say is like when you have a publication, okay, as a research faculty, you always try to publish it in your journal. But once after publication, if you think that this particular publication is liable for patentable subject matter prosecution or protection, then you have got some period, 6 months period to file it in the patent office. Like means that once you before publishing before filing it in the patent office, the journal publisher will not be having any idea about for the patentable prosecution. But once it is published in any journal, and if he or she comes to know that it can be published or can be filed in the patent office, then you got 6 months period of time from your publication in journal to filing in the patent office to prove yourself that you are the owner of that particular publication. Since the Patent Act will always under Section 21G of the Patent Act, anything, any invention, any innovation should be novel throughout the world. The examiner and the controller here, they search the worldwide database and comes out with the citations which may lead to your novelty killing as a document. So in that manner, it should be novel throughout the world. And the rights are territorial in nature, but limited to the boundary of country, but registration is required in each country except copyright. So registration is done by the concerned country. When you are filing it in the Indian Patent Office, it is applicable only in India, and you have to file. Renewal fees has to be paid for some IPS, like as I said. This is the nomenclature, or we can say that chart in which the various organizations, various institutes have been located in various locations, wherein the patent, designs, trademarks. You can file patents, designs, applications in Chennai, Mumbai, Delhi, Calcutta, if your place of business is related to that particular jurisdiction. If you belong to, if the place of business is in Mumbai or in the western parts, western states, then western states can be governed by Mumbai, and the northern states will be governed by Delhi Patent Office, Delhi Designs Office, Delhi Trademark Office. And similarly for eastern side, it is Kolkata Patent Office, Designs and Trademarks. And similarly for southern states like Tamil Nadu, Andhra, Kerala, these things, Telangana, Andhra Pradesh, these states will be covered under the jurisdiction of Chennai Patent Office and Chennai Designs Office, Trademark Office. This is our website ipnet.gov.in, where you can get all the information about the patents, designs, fee structure. You can search in the public search can be done. When you put some keywords with your own input in the particular field of technology, then it will give you a list of patents which has been published or patented in particular thing. You can see the dynamic utilities, wherein you can see that what is the status of your application, whether it is the examination procedure, it is pending, it is under a process or whatever it is. So you can see the controller's decisions on all the manuals and guidelines have been given, like for 3K, 3 year, and food and all the other guidelines have been given. So what can I do with the IPR? So IPR protection you have. You with the IPR knowledge you can find a patent, designs and trademarks, get the royalty and license. Or else if you know the knowledge about the patent patent rules and regulations, go through the patent rules and regulations. The patent agent examination will be conducted mostly in the year, mostly in the starting of the year, January and June. Now it is like only in initial, only one time in the January month, wherein you can file an application for to become a patent agent. Anybody, any science graduates or engineering graduates, they can file the patent agent. They can appear for the patent agent examination, in which the patent rules and regulations are being created, or rules have been studied, and you have a paper one and a paper two. Paper one, then you have all the choice based questions, and in afternoon session, you will have a descriptive questions in which you have to draft the company specification, how the patent specification has to be done. After passing these two examinations, you'll be called for Viva. Then, after getting all the marks, if you are scoring 150 and above, then you'll be become a patent agent. You'll be awarded a patent agent number. You can do the freelance patent agent. You can become a patent drafting specialist. You can once in this field, you can become patent analyst. Can work in trademarks, copyright, and law graduates if you are a law graduate, or you can join the government office. This is a simple query, or you can say that the quiz in which how many famous trademarks are there available, just to have a question. And this is for yourself. You can put your answers in a chat box. Which type of IP protects a painting protected by artist? All know that it is on what protects the intellectual property creation created by fashion designers. What is the intellectual property creation like? And what protects advanced disc brake for bike developed by the inventors, whether it is protected under copyrights or patent or designs, trademarks. Job indication, what is the job indication here? Like ironing machine steam or PlayStation, World Wide Web, BMW. And what does the trademark protect? It is for the invention or logos that you have to give it. How long patents usually exist? 20 years. If you write an original story, what type of intellectual property gives you the right to decide who can make and sell copies of your work? So you all know that. You can brush up yourself, which we have discussed so far in all the previous slides. So this is to show you that what are the brands. So paintings, தஞ்சாவூர் தலையாட்டி பொம்மையிலிருந்து தஞ்சாவூர் பெயிண்டிங்ஸ்ல இருந்து பார்த்தீங்கன்னா it is a GI tag. கோயம்புத்தூர் பெட் கிரைண்டர், ஈரோடு மஞ்சள், கல்கட்டா ரசகுல்லா. After Calcutta, Nasik Valley oranges. So to find out what is it like. Applicant, invention, novelty under section 21J, geographical indication, filing. So we know that the Samsung has smartphone has S2 hundreds and thousands of patented inventions. I can say that sync and synchronize email, calendar, contacts, exchange, active sync. It is a patent holder includes Microsoft. Microsoft got the patent and they gave the license to Samsung. And mobile operating system Android OS, the patent holder is Google. So here I just wanted to say that Alexander Graham Bell applied for a patent for the telephone on February 14, 1876. Only few hours before, another inventor, Elisha named, handed his application for a telephone as well. Had Bell waited for one more day to apply for a patent, Elisha would have been considered as inventor of the telephone. So what I'm trying to say is first come first service. Here, the same invention with the same topic, two people can come, two applicants can come, they can file it in the patent office. But today, if you are filing it, and tomorrow some other people or some other inventor is coming and filing it, the person who is come already first has been granted a patent application. So that is what the first in, first out. So we can have any queries in the chat, we can discuss. Otherwise, we can go to another slide.
Dear participants, if you have any questions, kindly put it in the chat box.
Or you can have it. So here, okay. Sorry, I had some sounds from the slides. Please bear with that. It is not shared. Is it visible, sir?
Sir.
Documents for filing a patent application. These are the documents which has to be. Hello.
Yes, sir. It's not visible, sir.
Not visible. Once. Share document. Ah, yes. Now.
No, sir.
I am trying to share the another screen. I shared the screen, sir, but it's not appearing. The another slide for filing procedures. It is appearing for me, but it is not.
Sir, can you send me in the WhatsApp? I will share, sir.
This has to be shared through window or entire screen, sir.
Windows, sir. Windows or entire screens?
Is it now?
Now it's visible, sir.
Now it is visible. Okay. So these are the minimum documents.
Sir, now it's not visible, sir. Now it's not visible.
Okay. Now?
No, sir.
Not visible, sir?
No, sir. No, sir. Sir, can you send me, sir? I will share, sir.
Oh, okay. I'm trying to answer. It was working fine. The previous slides, but what happened to us? I I just stopped and that slide and I've shared it to you in the WhatsApp. Patent filing procedures, 28 MB.
I will check. I will check, sir. I will check.
About the filing procedures.
Huh.
Till we start, anybody has questions, we can have the questions.
Dear participants, if you have any questions, kindly put it in the chat box.
There they can unmute them and then they can raise the hand. They can raise a
Sir,
hand.
they cannot unmute, sir. They cannot unmute, sir.
Okay. Can non-technical Apurva Balakrishna, they have raised the question. Hello, sir. Can non-technical subject like accounting can have a patent? Definitely, it is not possible. The thing is like it is not like that. It cannot file it. You can file it in the patent office. What I'm trying to suggest is, as per the section 3K, which is not having any technical effect, any invention which is not having any technical effect or business method, computer program per se, will not be eligible for patentable subject matter. So for your question, I'm damn sure that it is not patentable, but you have different formats of claims of protection. With that, you can apply for a patentable subject matter. Then you can go for it. But in this question, I can say that it may be you can go for you can develop a software, and that for that software you can develop as a trademark. You can go for a protection of the trademarks. So that is my humble suggestion.
Sir, is it visible, sir?
It's visible. Like you can move it. I
Yes,
can't
sir.
move it.
Yes, sir. Yes, I will do, sir.
Yeah. So here the documentations which is required for filing the patent office. these are the documents, Form 1, 2, 3, 9, 3, 5, 9, 18. So these are the documents which is available for, which is has to be applied to the patent office to get it rightly for the patentable subject matter to be protected. So it can have the, the documentation. There are two types: provisional specification and complete specification. Provisional specification is nothing but which gives you the validity for the priority, and the provisional specification which gives you the complete gist of not a complete gist, it is a kind of a document which is having only the specific nature of your invention, not the complete in final. So this provisional application from data filing to till 12 months time period, you have to convert from provisional to complete. So the complete specification has to be given for proceeding properly, proceeding in the prosecution of the patent application. So all the documentation should be in the A4 sheets. You can that within one page only, not in 2 pages printout. Only one page printout it has to be given, and this is the fees with abstract drawings, proof of right, the power of attorney if it is needed. If you are giving a power of attorney to somebody else to prosecute your patent application through a patent agent, then the power of attorney has to be given. So these are the things which is required for filing in the patent office. You can go to the next slide, sir. The size of the documents, it depends on the A4 sheets, it has to be given, a clear margin. So under section 10, these are the things has to be followed. Provisional specification is the difference. Provisional complete in the difference in pathina. Provisional specification will have the gist of invention and abstract material file panilla. From filing of a provisional specification, you got 1 month's time period to convert it into complete specification. Go to the next slide, sir. So this complete specification will have different formats. Title, embodiments, description of the invention. No need to give the claims in provisional, but in complete, go to the complete set. So only synopsis of the invention can be given in the provisional specification to get the priority. Like for example, if you got an idea today itself, idea as such cannot be patentable, or it should be in the expression of an idea. And the expression of idea, you got 12 months period to convert from provisional to complete. So you get the priority from that date itself. The complete specification has these contents like title, field of the invention, prior art. Prior art in the sense like the previous published patents or granted patents which are related to this particular field of technology. And what is the drawback in the previous review of literature survey? It is similar to that one. So drawbacks on prior art and comparing the prior art with the invention, how we are overcoming it, complete description, summary, different objectives, and a detailed description of the invention. And comes a claim part, which is the most important part, wherein you can get the protection for that particular thing and abstract. So it is a complete content which can give you the complete picture about the complete specification. So with these things only you can proceed with the examination procedure under section 11B of the Patent Act. Next slide. So the title and so all these slides you can go one by one. All these slides are under the section 10 of the Patent Act, wherein how the title should be, how the what are the whether it should be clear and concise, or how many words it should have. All these things have been given. Go to the next slide. Title, background of the invention, field of the invention, summary of the invention, and prior art in the sense like which is already there in the patentable subject matter. That difficulties about the limitations which is coming out of that particular invention or patentable subject matter is to be given, and how we are overcoming that with your own input. Other than the description, objectives, different objectives it should be given. difficulties and disadvantages which is associated with the prior art, how we are achieving it with your objective, summary of the invention. The inventing concept in general should be brought out here. But complete specification, description, specific how the invention is being achieved, that has to be given in the description of the invention. Next. Brief description of the invention. The description should be very clear, concise, and it should give the invention as to enable the person skilled in the art. அதாவது the description, once you go through it, the complete specification, once you go through, once a person who is involved in that technology, who is having some little knowledge about the technology, that is called person skilled in the art. If he goes through the complete specification, he shall be make use of the invention, make and use the invention without any further experiment. So, on the documentation has to be given, that description has to be given in properly. Next. Claims, which is most important part. These are the things which has to be followed, very clear and concise. It should be supported by description. And like for example, if you take if you have done something, invention in the indoor unit of the indoor unit and outdoor unit, you have the AC mechanism, and some kind of hardware equipment you have developed in the indoor AC, and that particular equipment or device which is making the indoor equipment to work in an optimal way to get the dust free at all, which cleans automatically, for example. So that particular device can only be claimed for the protection, not for the entire indoor AC or outdoor AC. The AC mechanism has already been protected, the indoor mechanism already been protected, but still here the device or the methodology by which the indoor unit is working, or optimistically it is working to give a enhanced output, that particular device or methodology only can be claimed for the protection. That is what the principal claim. That is for the claim protection. Next. So that is what we were saying, that the claims only makes the patentable invention as a patentable subject matter, patentable complete specification as a techno-legal part. ஒரு இன்வென்ஷனுக்கு ஒரு பேட்டன்ட், not multiple inventions. You can have multiple inventions and multiple patents, no issues. Claim should be supported by description, and principal claim is the first claim for which the essential feature of the invention should be given, and preferred features may be given in the subordinate claims. Next, sir. This is an example wherein I can bring you out the how specification can be drafted. For example, the prior art, the existing prior art in a way, it is nothing but patentable subject matter, patentable, already published patents or granted patents. This particular prior art is nothing but a rock, in which the rock is very hard, and the invention is about a table, in which a table. So rocks only we cannot carry it. It is very not comfortable. It is very difficult to carry, and you cannot place the articles on that. That is a difficulty. So as an inventor, I am coming out with a flat surface thing which is having some legs. That is called table. So that is an invention. Now, how you draft a complete specification for that? So the title can be like this. These are the formats, like apparatus for placing articles, an apparatus with the 4 legs and flat top, an apparatus with the legs and flat top. These are the things. These are the various categories in which the description about the table title. Next. So title has been given. Next, field of invention, then body of the invention, and what are the difficulties in the prior art, and how we are overcoming it, and what are the objectives, and summary. So this is how we have to draft the claims in which like this is an example, simple example. So an apparatus with the legs and flat top, that can be a title. The invention relates to what is the field of invention, field of furniture, and what are the background. The rocks are very heavy and it is not comfortable, and that is the reason like a flat surface of a table has been created or invented with the legs apart, and how you are claiming it, like. So the in this particular example, and you are claiming as an apparatus, as a device which is having a flat surface, at least one leg, and a top flat surface. So independent claim or product claim. So an apparatus has claimed in claim 1, the subsequent dependent claim, wherein the 4 legs are, where you can have any number of legs, 2 legs, 3 legs, and 4 legs, and it should be separated in what dimension it should be like. And the process by which the table has been created or manufactured or processed or fabricated, that can also be claimed. So you have a protection for the apparatus and you have a protection for the process of making an apparatus by giving a complete protection of your product line. Like for example, this is how the complete specification should be drafted. Like in the next slide, it gives you the complete picture about the drawings. Next slide. Drawings gives you the complete picture about different drawings. We should give a application number and reference numerals. It should be given properly, and the signature of the applicant should be properly signed in the particular bottom right of the paper. Like next. So any application like it should be drafted in such a manner that it should describe the invention, the best method of invention, the best method of invention shall be described in your complete specification, and it should give a complete picture about your invention. What is not claimed will not give a protection for your life. So you should have a complete knowledge about your invention, and the same thing should be claimed for protection under the patent specification. Next, sir. Next slide, sir. So these are the procedures. You can amend the documents at any point of time to meet a novelty and to meet obviousness. A voluntary amendment can also be done by the way of paying the fees of Form 13. That is the fees. That is a fees form for the amendment of any documentation which is involved in a company specification. Next, sir. Next slide, please. Next. Now, this is the complete picture about your entire prosecution history, what is happening in your patent office. You file it, and in normal route it is 18 months, but early publication, if it is if you are filing Form 9, it will be published immediately, and from filing to request for substantive examination Form 18, you have 40 months time period. But nowadays, like we can file it all the documentations like Form 1, 2, 3 and 5 optional, Form 9 is your option, Form 18 can do it together in a single day itself. So that is for Form 18, request for substantive examination. After you file a request for examination, it will be screened, it will be scanned, and it will be allotted in our automatic pool. And based on the subject matter or classification of your invention, it will be allotted to particular examiner who is specialized in that particular field. Biotechnology is one group, electrical and electronics and computers is another group, and biomedical, that is another group, mechanical and analysis is one group, and chemistry and inorganic chemistry is another group. So if your invention is related to computer science, it will be allotted to the electrical group. The examiner will examine the list of objections. He will search for the novelty and inventive step of the objections to the particular invention, and gives you citations as a list of objections to the controller, and the controller will review it, verify it, and issues a FER, first examination report. And after issuing the first examination report through email, the valid email ID which is prescribed, which is given in the Form 1, which will be communicated through that Form 1 only. Form 1, you have address for service, in which you have to give the complete address for service, which is a valid email ID and phone number, in which it will be communicated, the FER will be communicated. Then you have to give a reply to in 6 months. 6 months you give back, and if the reply is okay, then the controller will grant it. If it is not okay, then another list of objection will be granted. Then after that, the list of objection, you will be called for a hearing notice. You will be called for a hearing through PC. You have to explain everything before the controller. And from that hearing date to 15 days time will be given. You have to produce all the documentations and hearing submissions. And based on the hearing submissions, the grant or refusal action may be taken on that. So this is the entire procedure for patentable granting of a patent or disposing of a patent application. In between, there is a pre-grant or grant. Before granting of a patent, any third party can oppose your grant of a patent. That is called pre-grant opposition. So he'll be called and his documentation will be considered, and your documentation will be considered. Pre-grant hearing notice will be given to both of you. You have to appear both on the before the controller. The controller, based on the hearing, they will be given a time for another 15 days time. You have to produce the documentations and reply, and controller will analyze and verify the same thing which is given by the opponent and the control and the applicant. Then it will be processed and it will be granted, or the pre-grant, either the pre-grant will be disposed or it will be allowed to oppose the patent. So that is called pre-grant. Similarly, after grant of a patent, for any within period of 12 months, it can be opposed by any third party throughout the world. So that is called post-grant appeal. So that is also another kind of a procedure. The controller will have it, and the board will be formed, and based on the hearing from both the parties, it will be heard. Accommodations will be verified, and either it will be granted or disposed. This is the entire procedures involved in the patent prosecution. Yes. So with this, I think we have done the complete picture about the different forms of IPR, how the IPRs are classified, and what is the lifetime period, what is the filing fees for different forms of an IPR, designs, trademarks, and what can be filed and which cannot be filed. And similarly in patent also, under section 3, some inventions, patentable inventions, some inventions are not patentable under section 3A. It is not patentable. Section 3A, section 3 of Patent Act says that it cannot be patentable. Computer program per se, method of agriculture, and horticulture cannot be patentable. So these are the things which is not patentable at all. So you can go through our website ipindia.gov.in, in which the inventions which are not patentable, and invention which is, next slide sir, invention which under section 3A, which is frivolous, which is not obviously contrary to well established laws and natural laws, cannot be patentable. Section 3B, which says that an invention which is primary or intended to use commercial exploitation contrary to the public order or morality, which cause serious prejudice to human health, cannot be patentable. Mere discovery of scientific principle 3C cannot be patentable. Mere discovery 3D, mere discovery of new form of a known substance which does not give the result in enhancement of the known efficacy, that cannot be patentable. 3E, substance obtained by mere admixture resulting in aggregation of the properties of the components thereof a process produces a substance. This section 3D and 3E are related to chemical related applications, pharma related applications, and 3E, 3F, the mere arrangement and rearrangement of duplication known devices, each function independently one another way, cannot be patentable. For example, like umbrella fitted with a torch. So these things are two different patents, but they have been combined together or arranged together to give a kind of a patentable subject matter that is not patentable. Method of agriculture, section 3H, method of horticulture cannot be patentable. Medicinal, surgical, curative, prophylactic, diagnostic, therapeutic treatment of human beings cannot be patentable. On plants and animals, 3J cannot be patentable, wherein other microorganisms, but including seeds and varieties and species essentially in biological course, cannot be patentable. This can be protected under National Biodiversity Act. And 3K, mathematical formula, business method, and computer program per se. Computer programs as such is not patentable, but you can protect it in your copyrights. Literary, dramatic work, artistic work cannot be patentable, but it can be protected under copyrights. A mere scheme or rule, method of playing game, hypnotism, mental act, these things are not patentable. Presentation of information. If somebody is giving a new way of presentation of information, that cannot be patentable, but can be protected under copyrights. Topography integrated circuits also cannot be patentable under section 3U, but can be protected under semiconductor or layout integrated circuits. So, which is having invention knowledge, having a traditional knowledge, which is an aggregation or duplication of known properties of a traditional known component that cannot be, that 3P cannot be protected under 3P, section 3P. So these are the sections in which restricts the inventions not patentable under section 3 of the Patent Act. So it can be refused at any point of time, even the invention is bigger or whatever it is. Next slide. So these are the slides which gives you the complete picture about how the online filing can be done, and how the TCS, they get the digital certificate and other things like. So other updates which can be done. Okay. So any further questions, sir?
Dear participants, if you have any questions, kindly put it in the chat box. Thank you, sir. Thank you for your.
I hope I covered the 2 hours, right? From 2:30 to at least 4:20 now. So this 5 minutes to 10
The
minutes
chat box.
for chat box. I don't know what has happened with this slide. Why I cannot be shared.
Sir, I think it is a technical error, sir.
Okay, that is the only thing we can say ourselves.
So, participants, kindly share your questions and views about the session in the chat box.
So don't have any kind of what do you call doubts. You can file it in the patent office through provisional or complete. Let the patent office decides. Then accordingly your patent will be granted, either granted or processed. So whatever the descriptions of which slides I have shown you, that is from the Patent Act only under Section 10, how the complete certification should be, what are the things to be given like that. The last 5 slides which gives you the complete picture about the Patent Cooperation Treaty, which is shared to you, how the what are the timelines which is involved in the Patent Cooperation Treaty, how to enter into that, and what is the International Searching Authority, what is the timelines between the filing the national phase application, PCT application, and getting the ISR opinion, written opinion, how the international publication has been done, what is the fee, period of entry, 31 months for the data filing. All these things have been dealt in the next slides, maybe little bit advanced about the thing. That is why just not Patent Cooperation Treaty has something around 168 countries in which you can file your international patents. For getting international patents, you have to file it in India, get the permission from patent office. Within 1 year, you can file it outside India, like file a PCT application, and from 12 to 16 months, international search report can be developed, can be applied, wherein your invention will be processed and novelty inventive step and patentable criteria will be given by international search authority or report. Based on that, you can have an option to file to international preliminary examination report, or you can enter into the national phase. 31 months you got time from the filing date to enter the national phase. Like you can enter into any PCT contracting states like Europe, um, Japan, or some other countries like that.
Thank you, sir.
Yes, sir.
Of FDP on intellectual property rights. Sincere thanks to Mr. Raja sir, for delivering such an informative and thoughtful, provoking session. We are also grateful to our management for the vision and continued motivation in organizing academic development program like this. A special words of thanks to all the faculty participants for your active engagement. Once again, I thank you all. Thank you, sir. Thanks for accepting our invitation.
Thank you, sir. Thank you. I'll leave the session. Thank you. Thanks
Yes,
for your.
sir. Yes, sir. Thank you.
Thank you.